doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir.
By the time those requests morphed into the subpoena that was served on Fulton County, Ms. Merchant had been educated about what it was she was asking for and how to ask for it more clearly, which again could have all been accomplished had Mr. Bond not had the Ashleigh Merchant rule. And so all of that is to say this: what I'm going to ask for from the merchants is a proposed order that rules in favor, or proposed judgment, I guess it would be, that rules in favor of the Merchant law firm in this.
There's nothing more powerful than the odor of mendacity.
All right, welcome back Inside the Law. I'm your host, Philip Holloway. Look, we got some breaking news, and so sometimes when that happens, we're able to put together, maybe sometimes short notice, a live stream to talk about it all. Of course, this is the YouTube LawTube channel, I should say, where we bring you inside the real justice system, not the one that you may think we have just if you get all your information from the news or from watching movies, or even if you watch Matlock or other crime shows, because this is the real justice system. And we've got some big breaking news on some things that we've been covering here inside the law. Welcome to all of you who are here now and who may be watching later on replay. And of course, there's nobody better to help me break it all down because it involves her. Let's welcome it back inside the law, my friend and yours, just another country lawyer herself, Ashleigh Merchant. Welcome back inside the law. Ashleigh, how are you today?
I'm doing great. Thanks for having me.
Was a big day. Thanks for joining me on short notice.
It's been a big day.
Yeah. So so look, let's just dive right into it. Right. So we've got the appeal, right, from Brian Steele was found in contempt, right, by Judge Glanville, who subsequently got himself recused from the Fannie Willis versus Young Thug trial that we've been talking about, over how he went about handling this contempt. Of course, to set this up, Brian Steele is a lawyer representing Young Thug in this giant racketeering case involving Atlanta rapper Young Thug. And fast forward to several months into the trial, he becomes aware that the prosecuting attorneys have had a meeting. We call this an ex parte meeting because it's one-sided and it doesn't involve any of the defense lawyers. So he had a one-sided meeting in his office with prosecutors and a witness and the witness's lawyer, but nobody told the defense. They didn't know anything about it, which is highly unusual at best. And I'm being very generous, I think. And some would say unethical. Brian found out about it, and so he called to the judge's attention that he knew about it, and he was objecting to it. Judge Glanville came unglued, right? He just could not handle the fact that he did something back in his office and he was caught. Brian opposed it, and the judge demanded that Brian reveal how he came across this information. So please correct me if I'm wrong. I'm setting this up basically by memory, but that's the gist of what happened. And then, of course, you saw in the video that he says, no, I'm not going to tell you, Judge. This is none of your business, basically. There's legal reasons why I can't disclose this, and so I'm not going to disclose it. And he ordered him carted off to jail. So you can pick it up from there. What happened after that? Because I know you got involved on behalf of the Georgia Association of Criminal Defense Lawyers, which you're the president of, and of course on behalf of our colleague Brian Steele. Pick it up from there. What happened?
Yeah, and I love that you showed that clip, because I feel like that clip should be shown to all law students and all ethics classes, because what's really great about it, and this is what really embodies Brian Steele, anybody who knows him would agree, he's going to jail. He's taking his tie off. He's taking his coat off. He's doing all this stuff. And he says, wait, let me protect my client. Let me say something about my client's right to a fair trial while I'm being carted off to jail. That's what he's thinking about, protecting his client. And that is, it gives me goosebumps still to see it, because that is our job. And that is what he's doing. And he was incarcerated for doing his job, which the Constitution requires. The only way our system works is if we have constitutionally sufficient lawyers doing their job. And he was jailed. He was taken into custody. I read the opinion this morning, and just to catch everyone up. So why it's, a big deal today is we actually were scheduled for oral arguments today. So I was going to have the honor of doing the oral arguments in front of our Supreme Court. And they decided they didn't need them. And they decided they were going to release an opinion without oral arguments, which is a really big deal. It meant there was really no question in their mind, and this was a unanimous opinion. Everybody on the Supreme Court agreed with it. Justice Peterson authored it, and it was really to the point. And, I always like to pay attention to what's written in these orders. I thought it was interesting that Justice Peterson went through the history of how many times Brian had said, I can't tell you because it's confidential. And the judge just kept saying, you got to tell me, you got to tell me. And this is literally one of those situations where you're like arguing with your kid, which one of you took the cookie out of the cookie jar? I'm not going to tell. And they actually have a right not to tell. They have an actual privilege. They have a duty not to tell because it's confidential. And you just keep saying, well, I'm going to lock you up until you tell. You're in trouble until you tell. That's really what we were dealing with here. And as you read it, you're just like, wow, like the pressure of the court telling a lawyer, if you don't tell me what I want to know, even if it breaks your ethics, even if it breaks your rules, I'm going to lock you up. I mean, that's a scary thing for us.
And it's not like he would be allowed to sort of hang out in the lobby of the jail. We're talking about the Fulton County Jail, where people have died because they've been eaten up alive by bed bugs. So this was just a horrifying proposition. Now, I do remember that Brian said, look, Judge, if you're going to lock me up, will you let me be housed with my client so we can work on the trial together? I mean, I thought that was brilliant.
It was amazing, because if you think about it, he's like, I can't do this by watching a live stream. What he's worried about, he's not worried about being eaten alive by bed bugs, which is what he should have been worried about. Right. He's worried about, how am I going to continue to protect the constitutional rights of my client? How am I going to continue to make sure that this court doesn't run over and trample all my clients' constitutional rights? So that's why, as the president of GACTL, which is, you mentioned the Georgia Association of Criminal Defense Lawyers, we commonly refer to it as GACTL. That's why we have this strike force. Our focus when you're in court, and you've been in these situations, Phil, just like I have, we're so focused on defending our client. We're so focused on our job. We're not worried about ourselves. And it's really hard when your singular focus is doing my job, preserving my client's constitutional rights, making sure I object at the right time, because trials are stressful. I mean, if you miss an objection, that's not a preserved error. Like, you've got a lot of stuff to think about at the same time. And, he's doing all of this, and then he's worried about if he's going to go home at the end of the day. So, and I like the part that you just highlighted for your viewers, because, it was kind of surreal. I'll never forget the day walking in that courtroom and wondering if I was going to go home. If you've got a judge who is telling Brian Steele, you're not going to go home because you're not willing to violate your duty of confidentiality and tell me what I want to hear, with all of those parameters, after having an ex parte hearing, I mean, all that stuff, you don't know who else is going to go to jail. I mean, you really don't at that point. And the judge was so bent on that he was right and that he had followed the law. And he was so wrong about that you just didn't know what was going to happen next. But that part you highlighted, I mean, that's just kept repeating that in my head, that we've got due process requires this. Brian is entitled to due process. That is the fallback position always. If you're going to send someone to jail, you're entitled to due process. What is that process? What is that due process? And it wasn't followed in this case. And so, I love the simplicity of this opinion, talking about the facts. They didn't go into any minor details. They just said, Judge Glanville, you got it wrong.
So it was obvious to me that Judge Glanville did not understand the different types of contempt. And you actually showed up and helped to try to educate him, although I think it fell on deaf ears at the time. The Supreme Court, of course, has backed you up 100% everything you said in court that day, because you've got criminal you got two types of contempt. Let's just say you walk into a courtroom and you give the judge the old one finger salute, right? And the judge would be well within his or her rights to find you in contempt right there on the spot and throw you in jail, without a whole lot of due process, because you kind of forfeited it by virtue of the conduct that you engaged in the presence of the judge, because that's the kind of thing that disrupts the orderly administration of justice, right?
Mm-hmm,
and so the judge can throw you right in jail. But when it's something that doesn't happen, outside the judge's presence, or if it's something that maybe the judge is sort of involved in him or herself, which was the case here, they've got to give you essentially notice in writing and an opportunity to be heard. And that means a hearing or a trial, if you will, on contempt, where you're entitled to a lawyer, you're entitled to have witnesses and all this kind of stuff. So where was the breakdown here? And just kind of help us understand this Supreme Court's ruling. By the way, it went to the Supreme Court not because Mr. Williams, young thug, is charged with murder, but because some people in this indictment are. All murder appeals go to the state Supreme Court. So just walk us through this. What does this tell us about this? What does this ruling tell us?
Yeah. So just to kind of answer one of the things that you first brought up, though, this difference between criminal and civil, because I think a lot of people get confused at that. And it's not, it's not complex. If you think about it, criminal, when someone has a crime, a criminal case, the goal is to punish for past action. Make sure that you don't do it in the future by punishing. If you've got a civil case, you're trying to make someone do something. You're trying to force an act. You're trying to force someone to pay money or give a house back or give a kid back or pay alimony or, do something like that. Property. You're not punishing for past actions. You're trying to make someone do something. And that's the real difference here. And Judge Glanville, the problem was he was taking the stuff he wanted from civil and the stuff he wanted from criminal and creating his own version that was kind of a morph of the two, where you didn't have the due process of criminal, but you had the punishment, the incarceration. And the Supreme Court said, no, you can't do that. And so it was vindicating because it's what I said. In court, luckily, this is exactly what I told the judge when I walked in. It's always unfortunate when you have to go through the appellate process and you have to spend all this time and money, and when I say time and money, I'm talking about our courts are clogged. They've got a lot of things to do. They don't need to be doing something like this. So it's kind of unfortunate that they have to deal with this, but I'm glad that they did. And I'm glad that they dealt with it so quickly. And so what this essentially means is that Judge Glanville could not have heard the contempt. Someone else will have to hear it. And at that point, nobody else is going to hear the contempt. I mean, it's going to end. And this is one of those situations that cooler heads could have prevailed, honestly. You can just tell, you could tell from the room, it was palpable. You can tell from reading even the cold transcript, you can tell that the judge was mad. He was very mad. He is used to getting his way. He ordered someone to answer him and they did not answer him. And he was very angry at that. And he was punishing him for not answering him. And he lost focus on whether or not Brian should have or could have answered him and how to handle the disobedience. He just could not handle it.
Yeah, and to your point here on page 3 of the opinion, it says that they basically summarize this just like you just did, the Steele informed Judge Glanville that Steele had learned about the ex parte meeting and moved for a mistrial. Glanville stated that he was, quote, disturbed because that is ex parte. So he acknowledges that this is a ex parte or one-sided meeting, but I guess in his mind, to him, it didn't register that you're not supposed to do ex parte under almost all circumstances. Certainly, I think it was probably improper here to do it at all. So Brian really had no choice but to raise it. But the ruling goes on to say, quote, if you don't tell me how you got this information, then you and I are going to have some problems. So right here, you can see that his anger, his emotions are involved. And this emotional attachment to the issue is exactly why, Ashleigh, our rules require in the state of Georgia that in this type of contempt, that another judge were to hear it, right?
100%. And this is one of the reasons that whenever I'm talking to young lawyers, I say, if you get really mad, take a breath, take a day before you respond, before you put that in writing. You always need to take a little bit of time. And he could have, because it wasn't disturbing the proceedings. It wasn't one of those things where they couldn't move on. And the evidence was they did move on. They kept having the hearing. So it didn't have to be dealt with this way. It didn't have to be dealt with immediately. But I think you can tell from the parts of the transcript that the court cited that this was a very contentious type hearing. It was you do this or I'm going to lock you up, and just anger at the audacity of someone to defy a judge. And I think sometimes people forget that we're in a position where we've got a lot of duties as lawyers, and we're trying to protect our client. We're trying to protect their constitutional rights. We're trying to not violate our ethical rules. We're trying to not break confidentiality issues. And at the same time, we're trying to defend a case and win. It's a lot to keep straight. And, it's a lot to ask. And then you've got a judge who's saying you need to break the rules and tell me what I want to hear, or else your own personal liberty is at stake. You're going to be in jail. And Brian's a father, he's a husband. This was literally right before Father's Day weekend. Like, I remember when we had this hearing, I think it was a Wednesday, we didn't know if the court was going to grant a supersedious bond, and Brian was going to have to go to custody and spend Father's Day in custody for doing nothing other than holding up his ethical duties to keep information confidential. That's not how the law is supposed to work. It's just, it's just not. So I'm just really glad that the Supreme Court agreed with us and that they clarified it in case there was confusion, which, there shouldn't have been, but in case there was confusion, that this is not okay.
Yeah. Look, they quoted him here. He goes, Glanville says, quote, I don't want to hold you in contempt, but this is so sacrosanct that, to have a conversation in my chambers parroted by you and others, it's that serious. It's almost like Glanville doesn't understand that he was in the wrong.
Well, completely. But I actually think it's really important that you point that out as part of this ex parte, because it's the one issue that nobody has wanted to touch. And, it wasn't an issue in our appeal because our appeal was just the contempt of Brian Steele. But you can see this theme throughout. You can see it when in the criminal case, when there was a recusal and there was a new judge. New judge doesn't want to touch the validity of this ex parte. The pleadings that the state filed in this case, they don't want to touch the validity of this ex parte. Nobody wants to deal with that, because if somebody comes out and says this ex parte was illegal, they're essentially continuing to have an unconstitutional trial. Like, you can't undo that. This trial, this witness testified after this ex parte hearing. So it's sort of like the elephant in the room. Are we having a trial that serves absolutely no purpose other than to spend a lot of time and money, because it's already infected by error because they had this ex parte hearing. And, it's one of the shortcomings of the law. We can't really fix things until it's done. And, you can't appeal mid-trial. There's really no mechanism to do it. But, you can't help but wonder, this ex parte, if you think it was wrong, then this whole trial is illegal and going to be undone.
Well, here Glanville says, and they quote, you cannot eavesdrop and get information that was not meant for you to hear. Right. And that, to me, that's a confession that Glanville engaged in this conduct. And it's just like he's oblivious that it was wrong. Right. And apparently there was a discussion, like Steele said he wanted to get to the substance of the ex parte conversation first. Glanville says, well, you're going to be in custody until 5 o'clock.
Right, right. And I will tell you, I've seen the substance of the conversation. It was bad. It was just as bad as you can imagine. I think it's been released, the substance of the conversation was awful. It was, you're going to go to jail if you don't say this. You're going to be in custody for a really long time if you don't do what the state wants you to do, and you don't testify. I mean, it was bad. It was pretty shocking. So, I'm not surprised he wanted to deflect. And it's one of those things where, you get called out and you sort of get busted for doing something wrong. And instead of saying, you're right, I did something wrong, let's fix that, you're saying, oh, well, you did something wrong too. You didn't tell me. It's deflecting. And nobody's ever addressed the issue of the validity of this ex parte. And you can see in the order, there's actually, a reference in this appellate order, there's a reference to the state even arguing that the ex parte order was fine. I mean, they're still arguing that the ex parte, there you see it right there at the bottom of that last sentence. The prosecutor made several arguments as to why the ex parte meeting was not improper and why the information at issue was not protected by Rule 1.6, which is the confidentiality rule. So, you've got a prosecutor in the courtroom who, while all this is going on and Brian's getting locked up for this, not saying, hey, whoa, hold on. Let's look at this for a minute. Let's all let cooler heads prevail. No, Brian's getting locked up. And what are they arguing? They're arguing, oh, we didn't do anything wrong. The ex parte was great. It was totally legit, totally fine, not improper at all. And whatever information he has can't be protected by confidentiality. How would they know that? They don't know what he got and how he got it. How would they possibly know if it's protected by confidentiality? That's sort of the whole point of confidentiality. It protects where you got the information. And it's sort of like this blanket protection, for lawyers. Everything that you gathered throughout the file is protected. All of your work, witnesses you talk to, things like that. So, the state's there arguing, oh, this is fine. Don't look at us. This is fine. And, oh, I'm sure he doesn't have a privilege. How would they know?
Yeah. They don't know what he knows or what's in his file or there's no way for them to know. Yeah.
And clearly Judge Glanville didn't either, because he's accusing him of eavesdropping. He's going all over the place. He's saying, oh, you eavesdropped. But then if he eavesdropped, he didn't get it from a source. So it's clear that Glanville's just mad and doesn't know, because at one point he's saying, oh, well, you overheard it and eavesdropped. And then he's saying, oh, wait, actually, I think someone told you. Like he doesn't know, and it's insane.
Well, so it's almost like he thought Brian Steele was like outside his office door with a stethoscope, trying to listen in to the conversation. But it just seems to me to be intuitively common sense, like logical, that if you're a lawyer representing a client and anybody from any source brings you information that's relevant to your defense, that helps you with your defense possibly, or that you at least need to address, that you have an obligation to address it. Yeah. So the judge ought to know better than to try to force the advocate, the attorney, unless the attorney literally was out there with a stethoscope up to the door trying to eavesdrop. Then if you've got a problem, judge, with people talking, then you need to figure out who that was there, ask them if they're the ones that discussed it. And he tried to do that. If you remember, if those of you who might be new here or maybe don't remember, I know you do, Ashleigh, Glanville issued what's called a show cause order, setting a hearing for a couple of weeks out or something like that, where he directed everybody who was present to show up and to show cause why they should not be held in contempt for revealing the existence of this ex parte. It's almost like he was just obsessed with it.
Well, and here's one thing I want to point out before we move on. If Brian had not filed this motion for mistrial, if he had not raised this issue, and then let's say his client gets convicted and he's later on being called ineffective, he could very likely be called ineffective for failing to preserve this mistrial.
So can you explain to those folks, because that's a very good point, explain to the audience and the viewers watching now or later on replay, what it would mean when you say ineffective. What is the legal significance of a finding of ineffective assistance of counsel?
So basically, as lawyers, when we're trying cases, we've got to make sure we object to everything. If we don't, it's what we call waived. And it's one of the easiest ways convictions are upheld. So the lawyer made a mistake by not objecting to something. If we don't object to it, you can't later on appeal about that issue. So if Brian hadn't moved for a mistrial, later on, if he got convicted and this issue became, something relevant on appeal, he wouldn't be able to argue it. They would have to say that he had failed to do his job. He was ineffective assistance of counsel by failing to raise this mistrial issue. And that would be the argument. He would be subject to that, because if you've got something that some knowledge that you need to move for a mistrial, you need to move for a disqualification, something, if you've got that information and you don't use it, that can be ineffective assistance of counsel if it's a meritorious issue. And that's what this could easily be.
I like this sentence right here. This is on page, I guess, 7 or 8 of the opinion. Judge Glanville responded that an appellate court could tell him if he was wrong, and there were, quote, other bodies in Georgia that could review his conduct. So clearly we have the appellate court here telling him that, yes, Judge, you were in fact wrong. And I guess when he says there are other bodies in Georgia that could review I guess he's referring to the Judicial Qualifications Commission.
Oh, they footnote. Well, if you look at the footnote in that appellate opinion, I mean, they say that they're talking about that. And I'm guessing that's what Judge Glanville was talking about. But I mean, it is in there. It's in that footnote. They cited the statute that created the Judicial Qualifications Commission. And just for your viewers that aren't familiar, I mean, that's sort of the governing body for judges. Like if lawyers mess up and do something unethical, we have the state bar. That's who sort of governs us. But for judges, even though they are lawyers, they're not governed by the same rules as lawyers. They're governed by different rules. And so those rules are the judicial qualification rules. And that's the actual agency that enforces those rules. And that what they're citing there is the statute that says judges are subject to those rules.
So I want to talk about this footnote for a second, since you brought it up. They didn't have to drop a footnote here. But what you see, the number 2, the best information sometimes comes from the footnotes in these appellate
Always
opinions.
the footnotes.
And so they dropped this footnote number 2 here. And so when I see a footnote, I always want to look down and see what it says. They didn't even have to. You and I knew that he was referring to the JQC, but maybe the casual reader wouldn't know that. But so they dropped this footnote where it's almost like they are inviting the JQC to take a look at this. I don't know how you read it. It's like reading tea leaves. We just don't know. But I do know that they being the Supreme Court, they didn't have to put this footnote in, but They did. So they must have meant something by it.
There's a reason. If they list a person by name, if they list the Judicial Qualifications Commission by name, they're doing that on purpose. I mean, they mentioned the statutory authority that created that commission. They did that on purpose.
All right. So let's get into the end of it before we move on to your open records win yesterday. So let's see. We've got a footnote here, number 3. Let's look at that real quick. So Steele filed his notice of appeal in Superior Court in an emergency motion for supersedious, which is a bond,
right,
with the Court of Appeals. And y'all did that, correct me if I'm wrong, because Williams was not charged with murder, but because others in the case are charged with murder, the Court of Appeals, I think the Court of Appeals granted the bond and simultaneously transferred it. Isn't that how it went down?
Yeah, they did. And it's one of those things where this is so unique that there's no real footprint for how to handle this. I mean, this is so rare that something like this would happen, that, you've got I'm talking to a lot of really smart lawyers, some of the best lawyers in the state, and none of us can figure out, is it the Court of Appeals, the Supreme Court, which one? The Supreme Court can always take jurisdiction. They can always say it's ours. So they're able to. And I think what they're pointing out in this footnote is they're saying we're able to take it, and this is why we're able to take it. They don't want the imposition of having to take it, but they want the ability to be able to take it if they do. And that's essentially what they're saying here.
Yeah, it's like the Court of Appeals might have been able to do it, but there was no question that the Supreme Court can do it. And so in the interest of time, and it just makes it cleaner, it makes more sense. For
it was an emergency. Brian had 2 days to go to jail. And if you remember, Judge Glanville would not grant what's called a supersedious bond, which that is an appeal bond. What that means is that's the bond that you have to post to say you don't have to go serve this sentence. And the reason that they do that is because he would have served the sentence before this opinion even came out. So normally when you've got a contempt, 20 days in jail, something like that, you're going to have an appellate bond, a supersedious bond, so that you don't have to serve the sentence. Because if you went ahead and served the sentence before the appeal was reversed,
what's the point?
You're being punished for something that's going to be reversed.
All right. So, this is a great opinion. I've put it up on social media on X. I know others have too. It's out there. I mean, I encourage everybody to go and take a look at it. It's pretty straightforward stuff. There's some very, like I said, some interesting things that they drop in footnotes. And I do like, I think it's worth pointing out here. I'm on page, what page am I on? 13. It talks about, this is a great word. The contumacious conduct was directed towards the judge, or where the judge reacted to the contumacious conduct in such a manner as to become involved in the controversy. In that case, it must be conducted by another judge. Now, I don't know where that word first came from, but I know it's been hanging around in the annals of Georgia appellate decisions for some time. But this is exactly the situation that happened. There was some kind of conduct that the judge didn't like, and the judge became involved in the controversy. In fact, the judge caused the controversy, in my opinion.
Right. Yeah, no, definitely. And I can't even pretend to say that word.
It's not something that I come across that often. I must confess, I had to go look it up when I saw that.
I know.
All right. So anyway, so is there any appeal for anybody? Can Judge Glanville appeal this? Can the prosecutors appeal this? Or is this the end of it?
This is the end of it. I mean, practically there could be a motion for reconsideration, but practically speaking, this is the end of it.
Well, the prosecutors, by the way, it's like, this is great, where a judge does not act the instant the contempt is committed, but waits until the end of the trial. On balance, it is generally wise, where the marks of unseemly conduct have left personal stings, to allow a fellow judge to take his place. And that was from 1971. It's a unanimous opinion. Look, all y'all who were involved in this, I think should go without saying congratulations. It's great work. And Brian's a great advocate, of course, in his own right, but you guys did in my opinion, a fantastic job.
Well, thank you. It was our honor. Just happy it came out this way.
All right. So for those of you who may not have seen the very beginning of this, check this out.
By the time those requests morphed into the subpoena that was served on Fulton County, Ms. Merchant had been educated about what it was she was asking for and how to ask for it more clearly, which again could have all been accomplished had Mr. Bond not had the Ashleigh Merchant rule. And so all of that is to say this: what I'm going to ask for from the merchants is a proposed order that rules in favor, or proposed judgment, I guess it would be, that rules in favor of the merchant law firm in this action.
All right. So I don't want to steal your thunder, but just to set it up, you guys, this is all an offshoot of your representation of your client in the Fannie Willis fiasco. I call it the racketeering case against former President Trump and others. And you, being the Aaron Brockovich of this, had uncovered lots of information that brought to public light the affair between the District Attorney Willis and Nathan Wade, her then special prosecutor, and brought to light the fact that they had the existence of a personal romantic relationship. And of course, all hell breaks loose from that point moving forward. But you didn't get, Ashleigh, everything that you were trying to get to investigate that piece of it. So you resorted to the Open Records Act in the state of Georgia, and just, I know it's more complicated than this. The bottom line is they didn't comply with it according to the law. So you had to file a lawsuit. What happened?
Yeah. And, it wasn't just an offshoot of just a criminal case. People are allowed to just ask for, records just because they're curious. There were a lot of things happening in Fulton County, a lot of things happening in the news, a lot of deaths happening. There was a lot of funding issues, and I'm regularly asked to testify in front of the legislature, to give, public statements, things like that about what's happening. And so I try to keep up with what's happening. And at the time that I did all these open records requests, there was a lot of stuff going on with the Fulton County Jail. People were dying. They didn't have enough money. It was insane. And I was curious, why was everyone having such a hard time having cases prosecuted and moved through the system, where all the money was going in Fonnie Willis's office. So, one of the things I was investigating had to do with the case, the election interference case you talked about, but some of it had to do with other things, that I was investigating. And as a citizen, we are entitled under the Open Records Act to ask for documents that are public documents. And, anybody can ask for it. I mean, anybody, you don't even have to be a citizen, actually. I mean, anybody can ask for it, but we're entitled to those. We have to pay if it's going to cost time and money for them to actually get those documents. But the law says that they, as public officers, have to give us those documents, have to make them available. And, I was doing requests and they were ignoring me, or they were giving me part information and then closing the request out. That was one of the common sort of schemes where they would, they would give me part of the documents but they wouldn't give me all of them, or they'd be cut off or something like that, just really harassing, to try to force me to have to keep asking. So it's kind of ironic because part of their argument was I was harassing because I kept asking, but I had to keep asking because they kept shutting me down. So, apparently part of their argument was that I was persistent. I had to be persistent because they were persistently shutting me down and ignoring me. But yeah, I mean, and you're right. I see your viewer. It doesn't matter the reason for the request. I could literally be bored the reason for my request. It does not matter. I mean, it could be anything. And so, and I wasn't asking for anything crazy. I mean, none of these documents were like insane private things. I'm asking for a list of all attorneys hired by her office and the hire dates. Like, this is not, controversial, where the nuclear weapons are hidden. I mean, this is like, who works for you? How many lawyers do you have on staff? Like, pretty basic things. And they were saying, we don't have any responsive documents. So it became clear that there was a pattern. And you saw the judge call it the Ashleigh Merchant rule. It became clear that they were just saying, sorry, we're not giving you anything. And that just over and over again just kept happening. And we don't have a lot of remedies.
So I have a question, but look, most of the time, like let's say I'm trying to get the personnel file of a arresting police officer who arrested a client. So you file an open records request with the police agency involved, and they're a government agency, and these are records that they have to provide in almost all instances. And so you have a person that's designated in the agency as an open records custodian usually. But there's always some person who's, among other things, maybe it's their job to fill these requests, right?
Yeah.
And so in Fulton County, they run you, it's like there's just, Fulton County is huge. There's a lot of separate entities. You've got the tax collector's office, you've got the district attorney, but the district attorney is an elected official. They're not like the sanitation department. They're not like a bureaucracy. They are a bureaucracy, but they're like separate, kind of from the Fulton County itself, but they come under the county government for purposes of this. So it's like this weird situation, and you don't know when you've put these requests into their online portal, you really don't know whose job it is to field it. So fast forward to your trial on this case, you had a lawyer by the name of Dexter Bond, and that's who the judge was referring to. What is he a practicing attorney, or is his job just to do open records? How did this get before him?
So he is an attorney. I don't know if he's ever practiced law. And for me, practice law is, do you sign documents, go to court, things like that. I mean, you can practice law and review contracts. That's still practicing law.
Sure.
I don't know if he actually does practice, though. He is the deputy of operations, I believe is how he explained it, and the records custodian. So for our issue, it's he was the records custodian, which means, it really ends with him. He's the one that's responsible. This is his job. This is officially his job. If someone is trying to get records from the DA, he's the one that goes to court. He's the one that comes to court and certifies the records, things like that. So, that's his job. His job is to also, part of being a records custodian is to make sure that records are preserved. Because, the government can't just say, I'm going to put everything in the shredder and not keep it so that when you ask for it, I can honestly say I don't have it. You can't do that. And we actually have pretty extensive record retention laws in the state of Georgia. And you probably heard that come up a little bit. I mean, I know it's boring, but there's laws that say you can't put things in the shredder. There's laws that say you actually do have to maintain this stuff. So one of the favorite responses I was getting was, we don't maintain responsive documents. Like, oh, we threw them away. oh, that report that we filed 6 months ago, we don't have it anymore. We don't have it. We don't have our emails. We don't have any of that. Did they throw it away? Because the law says they have to keep it. So, I'm asking for things that they're required by law to keep. So I would assume they have the documents, and they were literally just trying to parse everything out in any way they could possibly parse it out to not respond to me. And that's the sum of his testimony. I mean, that's what he testified to. If I made the request, he was going to do anything in his power to read that request so he could say, pound sand, Ashleigh Merchant, you're not getting crap.
Well, I remember there was some testimony where he testified to the effect that he didn't really worry too much about, because he thought your lawsuit was frivolous. I mean,
yeah, he thought it was frivolous, but he didn't read it. So, he said
you won.
Yeah. I mean, and he said that, yeah, thank you for pointing that out. Actually, that's interesting. I hadn't even thought about that, but he's testifying that it's frivolous, but he hasn't read it. So, all that said to anybody watching is, I hate you. And anything you say, I think is frivolous because I don't like you. And it was just odd because I have no idea who this person is. Like, until I got a letter with his name on it, I'd never heard Dexter Bond in my entire life. Like, it's interesting sitting in court and hearing someone talking about, in January, how they absolutely just hated me. And the thought of seeing my name on a request just, was such a trigger to them. And I'm like, I don't know who you are, like I had no idea who he was until he sent me a letter saying that, pound sand, I'm not giving you anything. And, I get it. It doesn't bother me when people call me difficult. I mean, whatever, that's fine. I'm persistent. And you could probably see that in my questioning of Dexter Bonds, because I don't like it when people ignore me. I'm an only child. I don't like to be ignored. And so, I would ask a question, he would ignore it and answer a different way. Like, I'm not doing this for fun. I'm asking a question because I need an answer. And so I had to be persistent. Is that annoying? Is that difficult? Okay. I mean, it is. I'm going to ask the same question 5 times until you answer it. I'm going to do that. And if that's difficult, okay, then I'm difficult. I own that. That's not a problem. I don't go away easily. And so, that obviously can annoy some people, but I don't like to be ignored. And, and I know the law. And I know what I'm entitled to. And if you tell me I'm not entitled to something, and I know it exists, I'm not going to go away. So if that's,
I know that people are surprised. You're shocked to hear you say that. I'm Ashleigh Merchant and I don't go away easily.
I don't just go away. Like, you can ask my husband, him, John, you can ask him. Like, I don't just give up. I'm pretty sure he even said that. Like, you don't understand.
All right. So look, I mean, obviously you filed this lawsuit because they're not responding. Yeah. What do you think comes next? I mean, are they just going to go say, all right, we give up, here you go? Or are they going to appeal this? Or what do you think?
I hope they don't. It's interesting to point out, if you listen to the hearing, you probably also heard, that there was this Gonzalez opinion, probably heard that. It actually came down today and it completely sided with us. So, at the very beginning, the district attorney changed their tune several times throughout. At first, they said, oh, we're not subject to the open records. Guess what? We've decided we're not subject to the open records. We are exempt. We are, part of the executive branch. I'm like the president. I don't have to respond. So, that was their answer. And it was based on this lawsuit that was pending in our Supreme Court that said the actual opposite, but another DA had appealed and was trying to get what Fani Willis was saying to be the law. And that came out this morning. And guess what they said? No.
So they were arguing, just if I understand you, they were arguing that district attorneys could not be sued under the open records law. And of course, Judge Krause said that doesn't make sense.
Exactly. And in that other county, so there was just for the parallel, in the Gonzalez case, there was an attorney, a district attorney that had received open records requests, and she didn't comply with them. And she told them basically, kiss off, I'm not giving you anything. So they filed a lawsuit, and the superior court there, which is the same level as Judge Krause, that superior court sided with the person filing the open records and said, no, DA, you have to give these records. And that DA actually appealed it. So it went up to the appellate court because she appealed it. And she was trying to say, I'm immune from having to give open records and from a lawsuit having to deal with open records, which is just, it's a position that, 50 years of jurisprudence in Georgia, everybody knows the DA's office is part of open records. Like everybody knows that they have an open records officer. They literally have an open records officer, but they're coming into court and saying we're not subject to open records. Like it doesn't even make sense.
Well, it might be true that the district attorney enjoys, whether it's this one or any other DA, it might be possible that they enjoy some immunity from being sued for
personally,
how they exercise their prosecutorial discretion or things like that. But we're not talking about that kind of lawsuit. This is a statutory scheme created by the legislature that, it's supposed to be the thing that, they follow this law without a whole lot of pushback, but the law gives people like you, people who want records, it gives you an enforcement mechanism in the rare instance that they don't. Right. So
right.
if they meant to exclude DAs, they would have done it in the statute, and they didn't.
Exactly. Yep, they would have done it, and that's what the Supreme Court said today. So I think that just sort of solidifies everything. You asked what's going to happen next. I mean, judging by this, I have no reason to think that it won't continue to be litigious. I mean, we've had litigation after litigation after litigation in this case. Whatever theory of the day is. I mean, even yesterday, arguing for sanctions against me, like a new theory. There's a totally different theory now. We don't think we should comply because you're an awful person. I mean, that was essentially their motion yesterday. We don't like you and we think you're horrible. And so, I haven't even read the whole thing, but like flipping through it, it was like they said I had some personal vendetta against Fonnie Willis, and because of that, I should be sanctioned and the whole case should be dismissed. Like, no, I don't care. Like, I don't have any personal animus. Like, I just want records. It's not really that difficult. I didn't think it would be that difficult. But what I really hope that this does is there's, citizens who are just curious. I mean, there's little local newspapers that are, that's where things come to light. And I think that transparency is so important. And I just want to say this. I was in Fulton County yesterday, and they literally have this whole ad campaign about transparency, like on all their posters all throughout Fulton County. And I'm like, what? Like, then be transparent if that's the case. I think that government agencies should put their budgets online. I think they should put everything online. I think everything they do should be open to the public. I think the government is for the public. We pay for them. They should be proud of what they do. That's why anybody who asks me to testify, call me. I'm there. Like, if it's not privileged, like, I'm going to answer the questions. I have nothing to hide. And I think government agencies should be that way. And so it's really disheartening because there's so many people that don't have the privileges that I have being a lawyer to be able to do this lawsuit. I can go across the hall and beg my husband to file a lawsuit to get me documents. Most citizens can't do that. And they can't hire a lawyer to do this. It's expensive. And so I'm hoping that this is a wake-up call. And I'm hoping that the Board of County Commissioners, the taxpayers, all of those folks are like, this is not okay. You've got to be transparent.
Well, I would hope that the county commission was watching, because they see how the DA's office is causing the county attorney's office to get involved in this, and to basically whatever it costs them, I don't know, but it certainly cost them a lot in terms of public relations, right? It was a disaster for them. It just looked terrible. But speaking of damages, Ken, with this, thank you for the super chat, Ken. They get flagged, and it's brought to my attention. So he asks, he says the merchant law firm should get damages, treble 3 times damages, or for willful OR. So what are the damages? Obviously, the judge can order the records to be produced and things like that. But what are the damages that you can get under the open records law if you win one of these lawsuits?
Yeah, it's interesting. So in this case, and how we pled it, we can get attorney's fees. So the damages, so to say, is they have to pay for our time in litigating this, which makes sense. That's just making us whole. So it's not really punishing them. All it's doing is making us whole. And we didn't actually ask for any punitive damages. So punitive is really like punishment damages, where we would be asking for money to hold them accountable, sort of like a punishment. We didn't ask for that. We just asked for our fees, and we asked for the documents. We weren't trying to get enriched off of this. We just want to be covered for the time we had to spend to get these documents that we should not have had to spend. My whole theory is if I have to spend time away from my kids, it's going to be something I chose to do for free. I do a lot of volunteer positions. It's going to be something I chose to do for free, or I'm getting paid for my time, and I should be paid for my time. And that's what we're saying. We should be paid for our time. And that's what we got essentially. We got those, it's considered damages, but it's not really damages. It's just making us whole because we had to waste a lot of time on this. And we had to respond to frivolous motions. They filed a motion to dismiss saying they weren't subject to the open records request. I had to explain what these documents are so many times, just all of their tactics we had to keep working around. But to answer the question, I thought this was an interesting little tidbit. I was reading the law and I actually was looking up any prior prosecutions. And I don't know if you remember this, Phil, but a couple of years ago, someone who worked for the city of Atlanta mayor actually was prosecuted by the attorney general. I'd forgotten about this, for an open records violation. It is a misdemeanor in the state of Georgia to willfully violate the Open Records Act. And the attorney general prosecutes those. I had completely forgotten about that little tidbit, but that's not part of our lawsuit. And that's not part of what, I don't have that power. That's not me. But the attorney general could decide that they want to investigate. And, to me, I'm a criminal defense lawyer, so I tend to advocate for less prosecution. But what I can say is if this pattern doesn't get corrected, if they don't start taking it seriously, the open records violations. And what I mean by that is I had 20 emails in my inbox today of other people, other citizens who have asked for records and been told to pound sand by the DA's office, emailing me saying, oh, do you think I'll get my records now? If it is pervasive and they don't fix it, the attorney general needs to look at it because it's illegal and it's a crime.
All right. Well, look, you got 10 minutes to talk about Mr. Wade Goes to Washington.
Sounds like a lovely show. And he remembers going to Washington when he went to Washington with his parents when he was little. What he doesn't remember is going to Washington when he was billing in the most important case in his entire career.
So for those of you, what we're talking about is recently the former special prosecutor, Nathan Wade, was subpoenaed. Eventually, they were able to subpoena him to go to Washington to testify before Congress, right? And it was a deposition, so it's under oath. But it was behind closed doors, and it was brought to my attention by someone who had direct knowledge, and I posted about this on X, that former Georgia Governor Roy Barnes was in the room for the Nathan Wade congressional deposition. Okay. And in the letter, Roy Barnes says that Chairman Jordan needs to go to, it says, I would suggest you take some deep breaths and calm down so this matter can be discussed without emotion. An anger management course might also help. And he goes on to cite some scripture from the Bible, and he goes on to say something like, I'm just a country lawyer, unaware of the ways of DC, but I must, and then he goes on to say again that he'll talk about it when when Jim Jordan has calmed down and attended this anger management class. And I thought that was just a little bit on the absurd. It's just not a good look because what we thought was, it says at the bottom of his letter, counsel for Fani Willis in all capacities in which she may exist. Now that's strange. All he's got to do is say counsel for Fani Willis in her personal and official capacity. But then he goes up there and apparently he represents Nathan Wade too. And I'm wondering, what's going on? And then there's a picture here of him going in and it looks like he's there representing Wade. And of course it turned out that he was representing Wade. And I think you may have weighed in on this at some point in the comments, Ashley, but in any event, that's what happened. And then we've got this guy right here. We've got Nathan Wade's opening statement, where he goes into his background. He talks about him being a prosecutor at the Solicitor General's office. Rachel Kaufman was with us yesterday or day before yesterday and helped us understand that Solicitor Generals are misdemeanor prosecutors. They don't prosecute racketeering cases. But then it says he's a special assistant attorney general for the state of Georgia. And so I wanted to dive in on this. And so I posted that from my experience practicing law in Georgia since 1996, special assistant attorney generals are not really prosecutors, that they are contracted to handle certain matters, often civil cases, such as in juvenile child welfare cases. And I took a screenshot from the Attorney General's website, and then you actually provided the link, and your post in response to me says that this website lists every attorney who was actually a special assistant attorney general for 2010 through 2023. Guess who isn't listed? So if he was a SAG, it had to be pre-2010. And then this was mic drop. You said, I'm sure an open records request would clear that up. And I bet you the Attorney General will respond to an open records request with no problem.
Of course.
Yeah.
Yeah, they totally will. I mean, they have nothing to hide. Like, why would you not respond to an open records request when you're a government agency? It makes absolutely no sense to me whatsoever. But I'm sure they would. And so we would quickly know, because there's only one entity in the state of Georgia that appoints SAGs, and that is the Attorney General. So to be a special Attorney General, you must be appointed by the Attorney General. And let me just tell you, the Attorney General actually follows the record retentions law and will have copies of all of that.
Right. After all, it's the Attorney General's job to enforce this statute. So yeah, they're going to comply with it. So I wonder if any
to me though that something that can be that simply fact checked is in a letter to the United States Congress.
Well, so in my opinion, this opening statement, right? We've now got the transcript of the whole thing. Right. And I'll get your top line thoughts on that. But this opening statement that we got our hands on early, Wade basically gives his resume here, and it's almost, I don't know if you would call it embellishing or puffing, but to call yourself a prosecutor for having been a SAG working on deprivation cases in juvenile court as a contract attorney because the Attorney General doesn't have an office in whatever county you're talking about. That, to me, that's a bit of a stretch in my opinion. But then he talks about his private practice. And then he talks about serving as a municipal court judge. And so let me just say this. Municipal courts exist only for one reason in the state of Georgia, and that is to make money for the city in question. And it's usually in the form of, processing traffic citations, speedings and whatever, occasionally a shoplifting or a DUI, but more often than not, the overwhelming majority of their business is traffic tickets issued by the police. And so these municipal court judges, with the exception of the city of Atlanta, which has, I think, some full-time judges, I don't know of any other municipality, certainly not in Marietta, where I happen to be sitting right now, and I think you are too. In Marietta, it's a part-time, even the chief judge is a part-time judge. So if you're an associate, judge,
to be a municipal court judge.
I mean, is he just exaggerating, or does he want this to appear that he's got some extensive judicial experience? I mean, I don't know. Maybe it could be read that way.
I think it's trying to make it make sense as to why he was hired to handle arguably the most important state level prosecution in our country's history. Why this man was hired and why he was paid so much money to handle this case. Why him? Because one fact is known, that he was sleeping with the boss. So we know that fact. So in order for you to get around that fact, you got to be really, really good. There's got to be a really good reason that you, out of all the lawyers, were hired to do this case. Plus, there's got to be a really good reason that you can't do it in-house, because contrary to what Ms. Willis would like to believe, it is not common for special prosecutors to be appointed in the state of Georgia. I did an open records request to every single district attorney around the entire state. It does not happen. They do not have special prosecutors like this. This is a Fulton County thing only, that Paul Howard, her predecessor, started, and they've been able to sneak through all these years through the budget where they award people contracts that are friends of theirs. And if you look at the people that have been awarded contracts, it's people who have supported her. They are government contracts where you are basically saying, good job, thanks for supporting me, here's your gravy train contract. And that's what it was. And so he's trying to beef up his CV because he wants it to seem like he was some big catch that she needed to handle the largest case in United States history. that Nathan Wade somehow was the prize catch to handle this case, and nobody believes it.
Well, I wish I had thought to pull this up. You posted, I think it was another response to me on X. There was some testimony. Now that we got the transcript, he testified that he went to a RICO school or something like that. Please correct me if I got that wrong. But then you found it. There was a picture of basically another one of Willis's contract attorneys basically giving a class down in one of the classrooms in the courthouse where the DA's office is located to a group of DA's office staff. And it's
I wonder how much that cost the county taxpayers to pay one lawyer to train the other lawyer who's her boyfriend so that he actually knows what the racketeering statute is, because in his testimony to Congress, he's never had a racketeering case in his entire career.
So why not make that guy who's down there teaching a class, I wouldn't call it a RICO school, but if he's teaching a class to the DA's office on RICO, why not make that guy in charge of the case?
Why not make one of your salaried employees that you've hired to be an actual prosecutor one of the prosecutors on that case? Why not that? I mean, you have a budget to hire people. The state of Georgia gives you a budget. They give you a certain amount of prosecutors. Why not hire one of those folks?
Well, in the absence of Willis taking the stand or publicly stating, why she selected Wade, we are all left to our own devices to do the math and come up with our own conclusions as to why she chose him to be the leader of the band, so to speak, and not, as you say, one of the other full-time prosecutors or the resident expert in racketeering cases. But anyway, that Gladiator girl made that comment, and that brought that to my attention. And I wish I had the picture because it was beautiful. But in any event, I mean, that was what else stood out before we have to let you go. What else stood out from the transcript that you might want to talk about?
I was shocked at how much he did not remember, which, I testify fairly regularly in my practice. I mean, you just have to, I do a lot of appeals. And so how it works, but I end up having to testify later on about the work I've done. And I can't remember everything, but I will tell you the most important case in my entire legal career. If you ask me if I met with someone from the White House, I'm going to remember that.
Yeah, you're going to remember who you met with. So there was this, what you're talking about, there was this billing record, and I remember it from the court hearing. It was posted up on the, I guess the big TV screen in the courtroom. You got, one of the things you did get through billing records was, an entry that he met with the White House counsel, and then it said like a semicolon drive to Athens. So it looked like he drove to Athens, Georgia to meet with the White House counsel. But in any event, it clearly said that he met with the White House counsel, or at least White House counsel's office, but he would not directly answer that question when it was posed to him by the committee.
No, all he remembered was visiting as a child with his parents, remembered visiting the White House. And I'm sorry that, I can't remember everything. Like, that's why we take notes. As lawyers, we take notes. We need to be very precise. I mean, that's one of the things lawyers are. We are very specific. We write things down. We have to remember things. It is literally our job. And to have a case that essentially consumed your life for 2 or 3 years, the largest case in your entire career, I don't know how you wouldn't remember if you met with someone from 2 years ago. I just don't get that. I mean, I understand how, you might not remember what you ate for dinner 6 months ago. Yeah. But being in a room with other lawyers, White House counsel lawyers, you're going to remember that. So I just think it was incredible to expect us to believe that he had a complete amnesia to anything relevant.
Well, we'll leave it there with Ashleigh. I want to say thank you for taking an hour out of your time of your day to spend with us here inside the law. It's always good to talk to you. And of course, that you're welcome here anytime inside the law. Big a round of applause for my friend and yours, Ashleigh Merchant. Thanks, Ashleigh. Hope you have a great rest of your day.
Thanks. Good to see you, Phil.
All right. Well, there you have it, straight from the horse's mouth. And I'm not calling her a horse, but she is the person, of course, who knows this material inside and out, way better than I do. And even I'm sure others here following this or in the chat, you guys probably know this better than me, but there's nobody that knows it backwards and forwards better than Ashleigh Merchant. So we want to say thank you so much to her, and thanks to all of you. I think over 2,000 now in here live. I really appreciate it. If you haven't done so, please take the time to like this video and subscribe to the channel. We're over 50,000 now, so thank you for helping me reach that goal. My next goal is 60,000. I want to get to 60,000 subscribers. So if you think that this is a type of content that you might like to revisit from time to time, if you want to learn more about the real justice system, consider a subscription. Doesn't cost you anything here inside the law. And I've seen the folks in the chat just engaging in some really, really good conversation. I look forward to watching that on the replay. And of course, you can always leave comments after the live stream ends in the comments to the video. And I will look at those, and I will do my best to try to answer and respond to any questions that we may have missed. Thank you all very much for the super chats. And if I have missed anybody, I apologize. I try to do my best to acknowledge those. I really appreciate all of that. And look, here's the thing. I just want to remind you where this all started.
I'm asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
You've never gone to a cabin with Miss Willis?
No.
Have you ever gone to Tennessee with Miss Willis?
Yes.
Okay. When was that?
That was around 2022, early 2022.
Early 2022? Okay.
It was a day trip.
Okay, so you didn't spend a night?
So it was a day trip.
Okay.
We would drive there, have lunch, drive back. The reason we would do that is because the attention, she couldn't get any peace of mind going locally, so we'd get in my car and drive to someplace off the beaten path and have lunch and drive back.
So that's where it all started. Look, and let's not forget, we've got Ashleigh and her team. The defense is going to be arguing this appeal before the Court of Appeals in Georgia in December. They're doing it after the election, of course, but I think that it's certainly an issue that's worth following all the way to the end. The issue being whether or not the district attorney's office should be recused from further activity in this racketeering case on the basis of the just this. I don't really know how to describe it other than fiasco. I've called it the Fani Willis fiasco. And this is what Ashleigh has brought to light for us to use to learn something about how, unfortunately, courts sometimes work. I'm going to have to leave it there, but thank you all very much for spending some time with us this afternoon here inside the law. And until then, we'll see you back here next time.